Welcome to Court Explainer. Over the festive season, we are dealing with the Constitution of Kenya. We have looked at two arms of government. The first arm of government we looked at is the legislature. We have dealt with the executive. Today, we are dealing with the third arm of government, the judiciary. What are the principles? How does the Constitution deal with the judiciary? Chapter 10 of the Constitution creates the judiciary. And in Article 159, it provides the judicial authority. What is judicial authority? How can a young magistrate jail a young 25 resident magistrate, jail a minister? Can you imagine a very powerful old man being jailed by judiciary? What is this? Where do they get judicial authority? Article 159 is still saying the same way as we said, the authority of parliament, the authority of the executive, and now the authority of the judiciary is derived from the people and vests in the courts, tribunals, as established by under this Constitution. You are the owners. The powers of the judiciary come from you. And in 159.2, these are the guiding principles, and they are very critical. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. 1, A, that justice shall be done to all, irrespective of status. Nobody will be given a fair treatment, a differential treatment. When you are in court, all of you are equal. All accused persons are the same. All defendants are the same. And justice shall be done to everybody. Number 2, justice shall not be delayed. Justice shall not be delayed. Has your case ever gone to court and it has been there for 20 years? Are you a victim of the backlog, especially on land matters? Did your case about the land, your father or your grandfather's case, your grandfather went to court, he died, your father took up the matter, he died, you are now handling it, 40, 50 years in court? Now you know. Article 159 says, justice shall not be delayed. 3, it says, alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanism shall be promoted. So the judiciary is mandated to try to enhance alternative dispute resolution. Out of this condition, the judiciary now has what is called judiciary annexed mediation. Family disputes, a brother and a mother and a son, an uncle and a son. Your son, over Christmas, umenunua mandazi to be eaten on 25th. Your young child, your own blood, 8 years old, gets the ndazi and eats it on 24th. You go to the police and want that child of yours to be arrested because he ate a mandazi. The mandazi is theirs. The judiciary, if this child is brought to court, the judiciary will say, take this matter to mediation. The ODPP has that concept. In mediation, the ODPP can refer a matter to mediation. The police can refer a matter to mediation, arbitration. That is alternative dispute resolution. And the Chief Justice has been very, very categorical that 80% of the cases in court are not supposed to be in court. These are matters that are supposed to be dealt with through alternative dispute resolution. D, the judiciary is mandated that justice shall be administered without undue regard to procedural technicalities. Lawyers know the technicalities. When you go to court, lawyers know the procedural technicalities. The judiciary will always assist you if you are unrepresented. You cannot file submissions. You cannot do pleadings. The court will always listen to you. The courts are supposed to deliver justice, not based on technicalities. If you are told, for example, a case was filed, you are served, and you are told within 15 days, you are supposed to respond, and that summons came through on WhatsApp. You don't know that WhatsApp now is a mode of service. You ignore. Later, you are being arrested. The court will listen to you and say, now that you have come, let us proceed with this matter. Justice is bigger than technicalities. E, the purpose and principles of the Constitution shall be protected and promoted. And free, about ADR, the Constitution put it here about traditional methods of ADR. I know every tribe has a way to deal with their matters. The Somali tribe speaking dialect, they have what is called maslai. Somebody has been killed. The clan that killed the person of the killer, they get 15 gamias, they pay masla. That matter is resolved. A girl who is 12 years has been defiled. The defile and their family pay the mother. That community, those issues. That, how does the law deal with it? Have you ever compromised when your child has been raped, has been defiled, has been beaten, and you have been paid? Article 159, Sabbatical 3, talks about traditional dispute mechanisms shall not be used in a way that contravenes the Bill of Rights. 2, if the traditional dispute resolution mechanism is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality, or are inconsistent with this Constitution, those traditional mechanisms of ADR are not going to be allowed. And I've said, they do not apply if a child has been defiled, if a child has been sodomized, if somebody has been murdered. There can never be an ADR resolution. Forget about it. So, the Constitution is there to protect lives. If a killer has been arrested, the killer must be prosecuted and get justice. So, ADR is only applicable when it is not repugnant to morality and justice. Article 160 talks about the independence of the judiciary. Article 160 provides for the independence of the judiciary. The independence of the judiciary is so protected. We talked about the independence of the ODPP, the DPP. In the independence of the judiciary is only subject to this constitution and the law, and shall not be subject to the control or direction of any person or authority. The president cannot direct the judiciary. Nobody can direct the judiciary. 2, the office of a judge of a superior court shall not be abolished while there is a substantive holder of that office. So the politicians cannot say they can abolish the Supreme Court. They cannot abolish the Court of Appeal. They cannot abolish the High Court because there is a substantive holder of that office. Did you know that? The ones, because they are independent. 3, the remuneration and benefits payable to them shall also not be paid by anybody. The judicial fund, their salaries are not supposed to be paid as a token. They are protected. 4, subject to this, the remuneration and benefits payable in respect of a judge shall not be varied or disadvantaged. So their salaries and benefits are constitutionally mandated. And 5, this is now the most important issue. A member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. Can you sue a judge because he jailed your brother and you went to the High Court and he was acquitted? Can you sue a magistrate because he said your house to be demolished, then you rush to the High Court, that decision was stopped? Can you sue a magistrate who stopped the burial of your husband and you went to the High Court? The High Court allowed you to bury your husband? No. You can never bring criminal charges or civil charges or suits against a judicial officer while exercising his powers as a magistrate or a judge. But if a magistrate or a judge commits a crime outside here, or he does anything civil outside his job, he or she can be there. What are the offices created in the judges, in the judiciary? Article 161 provides for the judges and ranks. 1. Article 161 creates the highest office, being the Chief Justice, who shall be the head of judiciary. 2. The Deputy Chief Justice, who shall be the deputy head of the judiciary. C. The Chief Registrar of the judiciary, who shall be the Chief Administrator and Accounting Office of the judiciary. 3. The Judicial Service Commission may establish other offices. Then we have the superior courts, how the superior courts are created. We have in part 2, we have the Supreme Court. The Supreme Court is established and it seats 7 judges. A quorum is 5 judges. We wish to pass our sincere condolences to one of the judges who we lost, Justice Ibrahim Mohammed. So now the Supreme Court has 6 judges. Justice Mwilu is likely to retire. So we are likely to have 2 new judges at the Supreme Court. Judges of the Supreme Court retire upon the age of 70, or if they resign, or if they die. 2, we have the Court of Appeal. The Court of Appeal shall consist of judges not fewer than 12. The Court of Appeal can sit 1 judge or 3 judges or 5 judges or 7 judges. The Court of Appeal is the second appellate court in the judiciary hierarchy. We have the third one under Article 165. There is established a court called a High Court. The High Court is the High Court with original jurisdiction. And this is what I want everybody to know. The High Court has unlimited original jurisdiction in criminal and civil matters. So, matters criminal, and the High Court also has original jurisdiction to determine matters on constitutional violations. It can hear any matter that arises from appellates from the magistrates court. Then we have the Chief Justice. The Chief Justice, the tenure of the Chief Justice shall retire upon the age of 70 years. The Chief Justice will retire upon the age of 70 years, but may elect to retire at any time after attaining the age of 65. So at 65, the Chief Justice can retire. 2, the Chief Justice shall hold office for a maximum of 10 years or until retiring under clause 1, whichever is earlier. The 10 years maximum. ODPP, 1 term, 8 years. Then we have the Chief Justice can be removed by a petition being filed to the JSC. We shall be dealing with a JSC and other issues. Then we have the subordinate courts. Under Article 169, we have subordinate courts. The subordinate courts are magistrate courts, Kadhi's courts, court martial, and others which we call the tribunals. We shall be dealing with these ones when we will be dealing with those issues. Then under Article 170, we have what is called Kadhi's courts. I want to specially deal with the Kadhi's courts because people need to understand there is a Kadhi's court. The Kadhi's court only has jurisdiction on the following matters. 1, if you subscribe to the Muslim faith, that is when you go to the Kadhi's court. 2, the Kadhi's court does not have jurisdiction on matters criminal and civil matters. It deals with matters of personal nature of those who are Muslims. Then we have the Judicial Service Commission. Under Part 4, there is an independent employer of judicial officers. It is called the Judicial Service Commission. The Judicial Service Commission is an independent body that employs all judicial officers. The chief magistrates, the judges, the chief justice are employees of the JSC. JSC pays them. JSC disciplines them. Whenever a judicial officer, a magistrate, a judge misbehaves, you make a complaint to the judiciary, to the JSC. It is the JSC that will hear the case. If you prove that there is evidence, the JSC will recommend 1, for judges of the High Court, for judges of the Court of Appeal, and for the judges of the Supreme Court, a tribunal to be set by the President. If the tribunal finds that judge has committed an offense, the recommendations of the tribunal, the President will sack that judge. Judges have a security of tenure. Magistrates don't have security of tenure. So there is established a judiciary fund under Article 173. The monies of the judiciary is independent of the executive. Once Parliament has allocated that money to the judiciary, they run their affairs under that function. That explains to you that the judiciary is a very, very critical element. Wakili Danstan Omari, having brought you chapter 10 of the Constitution about the judiciary. Who joins the judiciary? Advocates join the judiciary, they become magistrates, they become judges. Make sure your children, encourage them to study law so that they can be judicial officers, they can be advocates. Wakili Danstan Omari, over Christmas. Enjoy your Christmas and Happy New Year. Thank you very much.